The authority for this is found in Article 5 of the U.S. Constitution, which provides two means for proposing amendments to the Constitution. One, which is by a two-thirds vote of both houses of Congress. The other is a, quote, convention for proposing amendments on the application of two-thirds of the states, unquote. The states and Congress have a level of equality in the proposal of amendments if one reads the plain language of Article 5 of the Constitution. Congress has never proposed a complete rewrite or new constitution, and it stretches the bounds of credibility to think that a convention of the states would do so. That said, in either instance, no matter what proposal comes out of either Congress or an amendment proposing convention, the second stage of becoming a constitutional amendment, ratification in 3/4 of the states, still has to occur. L.R. 6 calls for a convention to consider amendments for three purposes. These limited purposes provide the boundaries of consideration, but do not necessarily imply that proposals related to all of the topics would emerge from a convention. Those three purposes consider amendments which would, 1, impose fiscal restraints on the federal government, 2, limit the power and jurisdiction of the federal government, and 3, limit the terms of office for its officials and for members of Congress. Now, we can debate the wisdom or the need for even considering any of these issues as ripe for constitutional amendment, and that's fair. For those who don't believe that the federal deficit of $20 trillion is a cause for concern, it makes perfect sense for you to oppose. For those of you who believe that more power at the federal level is a good thing and that states should really just do those things that the feds let them do, opposition is fair. If you don't believe that the Congressional Budget Office's analysis that our spending and debt is unsustainable, then by all means, oppose L.R. 6 and the possibility that there might be amendments which would try to deal with that. If you don't believe that term limits for members of Congress is even worth talking about, then oppose this resolution. But if your opposition is about the process and the fear that it will somehow go awry and turn into a runaway convention, then you have failed to read your history or the plain language of the Constitution and of James Madison's notes on the Constitutional Convention. As the Constitutional Convention was wrapped up, George Mason noted that there was only one way to amend the Constitution that was being proposed, through Congress. As one commentator put it, quote, just before the end of the convention, George Mason objected that the amendment proposal would allow Congress to block as well as propose amendments, and the method was changed again to require Congress to call a convention to propose amendments on the application of two-thirds of the states. If L.R. 6 is passed, it will join a long history of Nebraska applications for an amending convention. In 1893, Nebraska was the first state to issue an application for a proposal which would call for direct election of U.S. senators. Because there were at least 3 versions of that concept being proposed by other states, Nebraska filed another application with different wording to match with another application in 1903 for the same purpose. It should be noted that while there were 3 different versions of an application for direct election of senators, and if you had added the applications of all the states that had applied for at least one of them together, that you would have had well over the two-thirds requirement, and no convention was called. This history demonstrates that both Congress and the states accept the limited purpose notion. It should also be noted that as the states approached the two-thirds number for one of the versions of the application, took action itself and sent a proposed amendment to the states, which was ratified in 1913 and became the 17th Amendment. In 1911, we were one of a number of states that filed an application for an anti-polygamy amendment to the Constitution. Now, I'm not sure if that was a significant concern in the country or not at the time. Utah had already been admitted to the Union after an explicit anti-polygamy clause in their state constitution. In 1949, Nebraska was one of a dozen or so states that filed an application for an amending convention for revenue sharing. There were also 2 applications filed with Congress on Nebraska's behalf in 1965. L.R. 14 dealt with apportionment and was made largely moot by the Voting Rights Act. and LR 42, which would have proposed a convention to consider an amendment which would make electoral votes proportionally allocated in all states. In 1976, Nebraska filed an application for a balanced budget amendment convention. LR 106 reaffirmed that in 2010. Or rather, that was LR 106 in 1976, and it was reaffirmed in 2010. That is an active application, and the Balanced Budget Amendment Convention has accumulated 28 states which have current applications, so they're only 6 away from the calling of a convention. And yet no one here has submitted a resolution to rescind that application, so you must be okay with a Balanced Budget Amendment Convention. In 1978, Nebraska filed an application for a convention to consider a pro-life amendment. That resolution was LR 152 in 1978. There are approximately 19 states that have active applications, including Nebraska, on that issue. My point here is this: LR 6 really isn't plowing new ground in Nebraska. Legislators have filed applications for a convention of one type or another every 20 to 30 years since our statehood. We will talk more about the process, I'm sure, but the process shouldn't be the reason for you voting for or against LR 6. The question that we should all ask ourselves is what we really believe as state legislators about the appropriate role of the federal government, and whether we as state legislators have the responsibility to use whatever means are at our disposal to attempt to rein in the power of the federal government and attempt to restore some level of fiscal responsibility to our national government. I look forward to the debate this morning. Thank you, Mr. President.
Sign the petition at cosaction.com and get as many of your friends and family to do the same. With your full address, your state legislators will know that you really are their constituents in their district. Our success depends on you, so we're inviting you to be part of history. Let's invoke the constitutional solution that's as big as the problem.